order the April 2nd meeting for Environmental Matters Committee. And for the record, all the members are here today. I'd like to start with approval of the minutes.
I move approval of the minutes. Move approval.
I second.
All right. All in favor?
Aye.
Aye. And now I'd like to invite Director Gutwald up to give a presentation about the development update. Thank you, Director Gutwald, for coming.
Sure.
I know the schedule has been a little confusing for everybody because we had to reschedule this last minute, but thank you for your flexibility.
But thank you for the snow day.
Yeah, my son enjoyed it.
Good afternoon, Pete Gutwald, Director of Planning and Zoning. I'll just update you on some of the major projects that are going on in the city right now as they relate to forest conservation, but if you have other questions, this information's you've been given this, and it sits on our website as well. Probably the first one I'll bring to your attention is 39 Hudson. That did have, we did do some discussion. I got some of that information from Mr. Regal and yourself, Mr. Savage. I think Tom had incorporated a lot of those thoughts and ideas, but he was coordinating with the county as well. He had a meeting scheduled. Again, I think it got moved on him as well, so he has yet to meet with Chris Saldano from the county about issues with that stream restoration project and everything. So there is some coordination going on, but it has yet to occur. And they have gone through the initial approval for the grading permit at 39 Hudson.
And so the concern had to do with coordination between the restoration project and the stormwater management on site, correct?
Right, correct. That's my understanding. So I know he had reached out. It's just getting the two together to talk about what's going on with their stream restoration, or what went on and what's going to go on this site. But I think a lot of the comments from the environmental community were incorporated into the forest conservation plan, from my understanding from Tom Smith.
And the stormwater management plan's not approved yet, right?
Well, the grading permit is part of that stormwater management, so yeah, it's got an initial approval anyways.
Oh, okay.
So,
Okay. So do you know, has Matt Waters looked at
I'm sure,
any of that?
yeah. I'm sure that's part of his preliminary approval is Matt's, all of his comments and thoughts are a part of that process, so.
Okay.
The next one, probably of interest, is, I don't know if it's listed, but I know Parole Place, which is out that same direction, is going under its FSD review, and I think they're trying to get their I think that review is complete and the forest conservation plan has been submitted. That's not on here yet, but I think that's just happened in it just happened the last couple of days, I believe. I would double check on that though.
And can you see if you have a hearing scheduled for that yet?
I don't think so. That's why I think he's trying to get that scheduled, along with the next one, Town Courts, which is at 2010 West Street. He's trying to do both of those hearings for the forest conservation plan scheduled at the same time. So
Okay.
That's what his attempt was. So that, I know, has been submitted, their forest conservation plan. This is across the street from the Monarch Academy on Capitol Drive. It fronts on West Street, but because of the stream right there, intermittent stream, they're accessing via Capitol. So, and that is the latest update on that one.
Can we go back to Parole Place?
Sure.
I thought they were held up because of the court case over 03517.
Well, that, to my understanding, is any new applications.
Gary? Parole Place is continuing to be processed. That was one of the two people that brought suit against the city on 03517. So how can their application be going forward?
Okay, I'm sorry, I was reading something else while you guys were talking, but I know that you're correct about
You're correct about Pearl being a plaintiff in that litigation, okay?
But
So-
I don't believe it stopped at existing applications. With that, the agreement withheld any new applications.
Correct. The existing applications are stayed pursuant to the injunction, preliminary injunction granted by Judge Harris, I think it was.
Right. We know it was.
Yes, yes, but I mean, that was by agreement, so we agreed to the injunction contingent upon the plaintiffs not being able to process existing applications.
Right, well,
That's
that's,
what it was.
this is an existing,
I thought-
and it's being processed.
They can admit, let's see, I don't have the consent order in front of me, but I think it was that the plaintiffs, they're entitled to amend their applications. They can't file any new applications.
Right, that's
it.
what I am.
They
My
can't file any new
new
applications. The existing applications, anything that's been
processed.
submitted and is in departmental review can go forward, including amendments to the existing applications. It's just new applications from the plaintiffs cannot be filed pending the injunction being in place.
Well, I mean, this will obtain to the Eastport Shopping Center too. If they want to amend their application, isn't that also stayed?
The existing applications, I don't know, I really need to get the consent order
Okay,
in front of
all
me.
right.
Take-
Well, I
Do you want me to go
just-
down
Sure,
and
it's
get
new.
it?
Go ahead.
I mean, it doesn't seem fair that we're stayed, but they're not.
No,
They
it's
continue to
mutual.
march
It's-
along.
It's mutual. We can't enforce O3517, but the plaintiffs cannot file any new applications while the preliminary injunction is in place. They can go forward with existing applications because those existing applications came in under the old law.
Correct.
Yeah.
That's
So
my
that's why
But if they
can-
want to amend an existing application, that's new.
No, no, it's not a new. They would have to withdraw the existing application and start over. An amendment to an existing application is relates to the existing application and comes in under the old law. Did they amend? I didn't hear whether they amended.
No, as he's asking about Parole Place, they submitted, I believe, I need to double check, maybe they didn't, but I'm pretty sure because Tom was trying to schedule the 2 public hearings for the forest conservation plans. They submitted a forest conservation plan. And Alderman Arnett is questioning how could they do that if we had this
Yeah, but they can go
agreement.
forward with existing applications because their status is not going to change. They came in under the old law, and even if the preliminary injunction is removed, they're still under the old law because they filed before the new law took place, was adopted. So we can't like retroactively apply the new law to old applications that were being reviewed under the law that existed when O3517 was adopted.
I think, well,
So-
I think we actually can, but I won't get into that
Not under that
here.
court order, we can't.
well, I think one of the questions is, though, when did they submit the preliminary forest conservation plan for review, and would that be impacted?
I have to see, it is recent, it's been recent. So it would have fallen underneath this 035, yes, absolutely. I mean, last month we were still doing the forest end delineation, but the application for the plan development came in prior to 035. The application, but not the forest conservation plan, so.
You probably should get that, I'm sorry to interrupt, because I remember that there was this initial language, and then Hyatt questioned it, and then it came, there was this language that speaks to what you're talking about specifically because of the active applications. It's spoken to specifically, I just can't recollect what it
In
says.
the litigation or in some other document? I mean, because,
It was the judge's
Okay.
clarified decision
Okay,
after
so the-
Hyatt had an initial
the-
comment or whatever.
so
filed.
the judge in the litigation passed an order granting a temporary restraining
Mhm.
order against the city, which was a 10-day order. During that time, the city negotiated with Mr. Hyatt on behalf of his 2 clients, and we came to an agreement. We submitted a consent order to the judge. The judge signed the consent order, struck 2 provisions of it. I'm not, without looking at the order, I can't recall right now which 2 provisions, but they were procedural rather than substantive. And then signed the consent order, which constitutes a preliminary injunction. Under the preliminary injunction, we had to introduce legislation to, in consultation with Mr. Hyatt, which we did. There was consultation with Mr. Hyatt. We, Alderman Arnett submitted a new piece of legislation to address some of the matters that were at issue in the litigation. And under the consent order, the language of Alderman Arnett's legislation was within the sole discretion of the city and Alderman Arnett, as long as we, collaborated with Mr. Hyatt in getting to a certain point. So the legislation was submitted, and I know Mr. Hyatt didn't agree with everything, but Alderman Arnett thought it was in good shape, and so did I, so we went ahead and submitted it. And at this point, just continuing on with the history of the litigation for a minute, when there's a public hearing, obviously Mr. Hyatt could come in and say what he wants to say then. He could come into the city council during public comments and say what he wants to say then. Or he can offer an amendment or two, or however many amendments he wants to offer to the legislation. That's allowed by the consent order. He can seek to have the city council accept any amendment that he wants to submit. As far as what happens to existing applications and new applications, the first thing is that the litigation can only govern the parties to the litigation. So we can't, the litigation cannot control what non-parties do or don't do. So someone can come in that's not a party to the litigation and submit a new application, and because O3517 is under a preliminary injunction right now, that new application, a non-party, I'm not talking about the two parties to the litigation, a non-party, would come in under the old legislation. We have to revert back to the old legislation while the new legislation is being litigated. Okay, so, but if new applications are submitted by the parties, let's put it this way, under the consent order, they cannot submit new applications. The concern, as Alderman Arnett clearly was concerned about, was that the plaintiffs would seek to submit new applications while,
Or amend it.
Amendments are allowed because that is not a new application. That is not a new application. So I didn't have any problems with them if they wanted to amend it. I don't think they've done that yet. Is that right, you're saying?
Well, let's not take up the committee's
Okay.
time on this anymore
All right.
here. I do think significant amendments should not be allowed, but that's that's a matter for downstairs. It just, what's good for the goose is good for the gander. Somehow it seems we're constrained, but they're not.
But it's an
And,
existing application. It's going to be
Well-
reviewed under the old law no matter what.
Let's, we could talk more about this. If you two could get back to us about an answer about the application, I'd also like to know if the preliminary forest conservation plan hearing is going to be impacted by the legislation. Again, if you could just get back to us about, because I know people are going to be interested in attending that hearing. All right, so, and just to clarify on that project, well, let's see, looks like 90 residential units over retail, 68 townhomes.
Yep.
Do you
Yes,
have
sir.
any of the, if you could send us a copy of the forest conservation plan, I'd like to, or do you have any of the numbers in terms of how much forest they're proposing to clear?
I don't, off the top of my head, I don't, but we can certainly get you that information.
Okay.
Is this special mixed plan development?
It is?
Are the 90 units over parking lots?
No, they're actually over the retail component.
Hey, how tall is the building?
Excuse me, Chair, I thought, were we going to include a column to have the acreage of clearing, or was that another Excel sheet?
Yeah, have you had a chance to consider that?
Yeah, we're looking into it. It's how much information, how we're going to be able to do that. 'cause
Only
it's
if
going
it
to
was
require
easy.
some manual labor. It's not going to be easily
Oh, I thought it was
extracted out.
information you had, and you could just add a column.
Yeah, I think
You don't typically.
was hoping that it was information we'd already have, but it's not. So
Oh.
I've looked into that far, so I think
Well,
I sent you an email about
I
that.
think when you get to the forest conservation plan stage, that information is required on the front of those plans.
Right.
So as long as they get to that point, you should be able to provide that on here.
Right.
It might be more difficult for the
All
project
the others,
earlier
yeah.
on and.
Right, to do a yeah,
process.
as we move forward, sure.
Okay. Thank you. Sorry, you can continue on.
Those were the major updates. I don't know
Okay.
if you have any more specific questions to any of the other plans.
Did Port Annapolis ever get their approval in time for the weekend for their new fuel pumps?
They did.
Thank you. Thank you very much.
You're quite welcome.
Any update on the
Listen.
Bembe Beach, Chesapeake Grove?
Nothing has moved forward on that at this point in time. We had some issues with getting plat stuff together, so the next move with that, once we figured out that and nailed down there is some issues with the forest conservation plan, because that was one of those things that got caught between Jan's review and us. And there's some questions as to what was the status of some of the information that was provided to us. Something, it's called open space. We didn't know what it meant, so we're still trying to figure that part out on Chesapeake Grove as part of their treatment. And not forest conservation, it's a critical area for Chesapeake Grove, but still trying to get some updates on the conditions of the trees, because it was unclear from the table. And it seems like Jan approved those waivers, but we weren't sure, so that's still caught in that cycle right now, so.
Okay.
And there's a couple of other pieces of information that I think Cynthia was looking for on that plan before we moved it to Planning Commission.
Okay. And you don't have a date for the planning commission yet?
No.
On the Central Park, 9 Elliott Road, any update on, I know there was some legal battle with, I
Ownership.
believe Hyatt in terms of the ownership of the
We've got
railroad
that,
grade.
we've gotten that squared away, yeah.
What's the resolution on it?
They did own the property, so,
Who did?
the Pastrana family owned the property.
They
The
own
city did not own it, so that's correct, right? Yeah. So we got that squared away, so we're still, I mean, that's moving along. I don't have a planning commission date for that one either. I think there was a couple of other pieces of information, but that was the biggest holdup right there, was with ownership of the property. And we are looking at the trail.
Is that going to impact
Shouldn't.
trail at all? Okay.
No, it shouldn't.
My colleagues have anything else they'd like to ask about?
I'd like to make a comment, once again, to thank you not only for the spreadsheet and it's involved over time, but also the alerts that you're sending out, because I actually looked at this ahead of time because of the email alert. So I think this is really, this takes time for the staff to do it, and we never really recognize what a big step forward this is. So I'd like to, once again, thank you for this and the staff that work on this, because it is very helpful. I know where to go when I get a constituent calling, asking, rah, 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 rah. So I do appreciate it.
Thank you.
Yeah, thank you.
Yeah,
Director.
thank you. Thank you very much.
Okay.
All right, next on the agenda, the Department of Public Works, but they're not coming until later in the meeting, so, yeah, Harbor Master, please do come up. So now we have legislation for the Committee 0718, Board of Port Wardens Appeals. Actually, we can, yeah, Gary, you want to do that one first? The Board,
Yeah.
Port Wardens Appeals?
Okay, yeah, Gary Elson, Office of Law. So during one of the proceedings before the port wardens recently, we discovered that there was a mistake in 1516-040C regarding appeals. And so this just is a correction. The appeal of a port warden's decision goes to the circuit court. which is stated in section G, a person aggrieved by a decision of the Port Wardens goes to the circuit court. That's correct. What is not correct in C is that the decision appealing a port warden, an appeal of a port warden's decision would go to the city council. That never happens. It used to happen, I think, a long time ago, but it doesn't happen anymore. And so when the change was made, I assumed that someone didn't catch that. So this has probably been in there quite a while, and we just caught it. So we just wanted to make the change. There was also a correction about transcripts in the case of an appeal to circuit court, and we corrected that. The cost of the transcript is borne by the appellant to the circuit court, and if the city were to not prevail in circuit court, then we would have to reimburse the appellant, but that's the case in any administrative appeal. The loser pays the cost of the transcript, so that's essentially what that reflects. That's it on that legislation.
Okay.
So this is largely a long overdue technical correction,
Yeah.
and I would move that we recommend approval to the city council.
I second that. That's the way I understood it as well.
Okay. Is there any discussion? I just have one question, I suppose. So previously, appeals used to go to the city council. And it looks like that was changed in the state level. The state code changed. I guess we had to get the state.
I don't think it was in the state code. It's not like in the land use article, where you would have statutes governing zoning and land use. The Port Wardens is not governed by the land use article. So we don't, this was just the way it was done in the city council. As far as I know, back then, it was before the turn of the century, shall we say. And the Board of Appeals, for instance, was created in the mid-90s. Zoning appeals would go to the city council then too. And so since those appeals were generally quasi-judicial in nature, much more than the city council could handle with the agendas that the city council has, I know the Board of Appeals was created in the 90s. The Port Wardens was created in the 70s, possibly the 60s. Yeah.
But I'm wondering though, because based on my research, we, in the past, when this was changed, we had to go to the legislature to actually get approval, because in the state legislature it said it had to go to the city council for appeal. We had to get that changed to allow it to go to the circuit court.
Well, I don't recall that being the case. There is a State Administrative Procedure Act which doesn't govern the city, but it doesn't govern municipalities, but it governs counties and the state. And that is something that's in the State Administrative Procedure Act, that appeals from administrative agencies go to the circuit court. And I think this just follows that line. I don't recall there being anything in state law which we needed to get in order to have an administrative process. So I don't think that required approval of the General Assembly. That's my that's my thought at this point. I certainly haven't researched it.
Okay. Well,
But I
I'll
think
send you what I have.
Okay.
Just trying to bring it up now.
It's possible it did, but I know that all around the state, appeals from administrative agencies go to circuit court. That's the last level of appeal in a municipality or county government.
Mhm.
And there's nowhere to go other than the circuit court from an administrative agency.
Here it is. The staff paper from 2004 says,
Where are you reading from?
oh, it's something Jacqueline sent this to me
Oh.
a couple of weeks ago. Says there's changing, back then, the city of Annapolis seeking a change to the annotated code of Maryland to clearly permit an appeal from Port Warden's decision to be made directly to the circuit court. This legislation was passed unanimously by both houses of the General Assembly. And the reason follows: in all differences that arise between any aggrieved party and the Port Wardens of that municipal corporation concerning the discharge of the duties of the port warders, an appeal may be taken to the legislative body or the municipal corporation. What was changed is they added, "or if authorized by the municipal corporation by ordinance to the circuit court for the appropriate county."
I don't know where she got that research from, but I can ask her about it.
It looks like Maryland Rule Title 7, Chapter 200. I don't know, I'm curious about, I guess, does that authority from the court ordinance come from that code or the Maryland rule?
7200 is rules of procedure. Those are not
Okay.
laws, those are court rules. So the Maryland Rules of Procedure, Title 7, Chapter 200, are the rules as to how you handle procedurally an appeal from an administrative agency to the circuit court. So that may have been adopted. That may
Okay.
have been what she's referring to, but rules are not laws. Rules just indicate procedures for this particular rule for what the court expects procedurally when you take an appeal. So you have to have a petition for judicial review. You have to give notice to interested persons who attended, at the administrative agency that an appeal has been filed to court. And then you have to certify who was notified to the court. And then there's rules for filing memoranda of law. Both sides have to file memorandum of law. And then there's oral argument. But that 7200 is the rule, or the rules,
Okay.
and not laws. They're not statutes. So that's the extent of the information that I can give you on those
Okay.
rules. But there has to be, in order to take an appeal, you have to have a statutory source of an appeal. Okay, so our statutory source is the city code. If you want to take an appeal from the port wardens, you go to the circuit court. I can give you an example where we didn't have anything, and that had to do with the Forest Conservation Act, as you probably remember. We adopted the State Forest Conservation Act, which does have rules for appeal. But Judge Harris, again, ruled that because it wasn't expressing in the city code, forgot what section it is right now. But at any rate, he ruled that there was no statutory right of appeal. But I really think that, I argued in that case that, look, we adopt state law. The state law has a statutory right of appeal. So that naturally, is how appeals are governed from the city, even though it's not expressly stated in the code. We did expressly adopt state law. He didn't agree with that. So I thought it was the wrong decision, but,
Yeah.
now we have it corrected because we have our own Forest Conservation Act.
Yeah. Okay. Well, for my colleagues' sake, I asked that partly because I know there have been some discussion and some frustration from the public having to do with the appeal process for the port wardens. So if we ever wanted to change the appeal body or create a new appeal body, I'm wondering if we would we have to get the Maryland Rule Title 7, Chapter 200 changed?
No, that doesn't change because, again, it's only what you have to do during the course of an appeal to satisfy court rules. Okay, you have to file this, you have to file that.
Okay.
The port wardens are like the Board of Appeals or the Planning Commission. Their decisions are final adjudications of applications that come before them, final administrative adjudication of applications. And that's what kicks it into circuit court on appeal. It's a final administrative adjudication of an application. So if you have a decision by Pete Gutwell, for instance, that's a departmental decision, and that goes to either port wardens, depending on what it is, or the Board of Appeals or the Planning Commission. The departmental appeals go to the agencies. The agency appeals go to the circuit court. And I think we're all good on this. I don't know of any particular law which caused us to take appeals away from the city council and create, for instance, like the Board of Appeals. But as I recall at that time, the city council just couldn't handle it was overwhelming, for the city council to have to conduct adjudications and quasi-judicial, hearings and then issue a written opinion. And so we created the Board of Appeals just for that purpose, to have our own zoning appeal agency.
Excuse me, Mr. Chair. Are you referring to the South Annapolis Yacht Club hearing, the port wardens? Because that got into a gray area and was frustrating because refresh my memory, their decision, they couldn't address the property dispute because it wasn't in there.
Right.
Yeah, so
Well-
that's an odd situation.
Well, real briefly, I mean, the application was correctly before the port wardens, and still is. We're in the process of writing the opinion right now. But the issue was raised by the opposition to that application about title to the SAYC property. They said that, as they claimed or alleged, that SAYC did not have title to the property that was the subject of its application before the port wardens. And, so if you look in the code, each agency has review criteria. The Board of Appeals has its own review criteria for certain applications. Planning Commission has its own review criteria when they consider applications. And the port wardens has its own review criteria. So in none of those review criteria does the board or the commission decide issues of title. Those are civil disputes between neighbors. In this case, it was Newport Condominium and South Annapolis Yacht Center, neighbors having a dispute about property lines. The boards and commissions of the city do not decide property boundary disputes. Those are decided in court. In the first place, the boards and commission members do not have the expertise to decide boundary disputes. And in the second place, the review criteria don't indicate that title is an issue in any of those applications that come before those boards and commissions that must be decided in order to approve or disapprove an application. So if someone wants to dispute title, in this case Newport disputing SAYC's title, they need to go to the circuit court. If they're going to challenge the application, they, at some point in the proceeding or before the proceeding, have to get an order from the circuit court adjudicating the boundary line dispute. They didn't do that in that case. We indicated during the port wardens hearings that that was not something that the Board of Port Wardens could decide, that their decision was confined only to the review criteria in the code. For instance, would the construction in the water affect wildlife? Would it affect conservation? Would it affect marine life? Would it affect navigational safety? Would it affect congestion in the waterways? Things like that. And the lateral lines also was a big issue. So the port wardens has to confine its review of an application to those specific factors which are designated in the code that say, the port wardens, this is what you do. These are the findings of fact that you make. And title issues are not indicated in the code. And I think rightly so, because that's something that the circuit court should be doing, boundary line disputes. They generally do boundary line disputes. That's where you take a dispute over boundaries if you have one with your neighbor, but not in an administrative agency. And so that's how that was decided in the port wardens. The opposition didn't agree with it, but I feel pretty sure we're right on that.
Okay.
So I offer an amendment that all appeals come to the Environmental Matters Committee.
I knew you were going to say something like that.
Any other discussion?
We'll get back to you on the other thing about the Forest Conservation Plan, whether that affects anything having to do with the application.
Okay.
We'll get back to you on that.
Any other discussion? All right, all those in favor?
Aye.
Aye.
Okay? All right,
All right,
thank you.
thank you, Mr. Ellison.
Okay.
All right, Harbor Master Velis, you're up. Yeah, so, yeah, just bringing up our notes on this. So this is in reference to R818, amendments to Title 15 of the fiscal year 2018 fee schedule. So I wonder if you could just give us some background on what this is before us.
Thank you. I don't have the list in front of me, I apologize, but I remember most of them, and maybe you can help me when I miss any of them. One of them is to take out the fee schedule, the section that offers $50 to keep your vessel at public street ending.
Doesn't have a dollar figure, though.
Yeah, page.
Yeah,
Oh, on page 2?
page 4.
Oh.
Right before that, Beth, is one for
Gotcha.
$30 for buy boats and
Sorry, I was on the staff report. Okay, gotcha.
So I've been told that that was. Can you hear me now? Okay. So I've been told that that fee addition was placed in by Julian Walters some time ago, and that they were allowing people to come in with a letter from their doctor and store their boat at the city street end. Unfortunately, as kind as that sounds, it's in conflict with the code 1512-020. And even if you interpret that in the broadest manner possible, if you look at paragraph C, that's not a finite group of people. And so unfortunately, I think if we continue with this practice, there were only 3 when I arrived at the Harbor Master's office in 2016, and my staff told me that they had stopped issuing them because they realized the problem they had created. And so those haven't actually been issued for some years, and there were no expiration on the stickers. So people were paying $50 and for 10 years storing their boat at the street end, with or without. Some did not have any medical documentation. Because of the limited amount of linear footage at our street ends, because we want them to be open to our visitors, to our residents that have mooring balls, and to our taxi, it is not a good practice, and to me it is in conflict of code. So I wanted to take that fee schedule out so people don't think that it's okay to do that.
I have a question for my colleague, Alderman Arnett. So the important point here is that we were charging a fee that was not codified, and is that, so if we have a fee, there should always be a code reference, or how do we know this doesn't happen again? You know, I know we have the fee schedule in the code, but how is that cross-checked with the code that triggered it, I guess? Do you understand my concern?
That's actually a good question. First of all, I think the fees stand alone. I'm not sure that you could trace each one of these back to a section of Title 15. For example, passenger carrying chartered dock space may be reserved in advance. Mooring shall not be used. I mean, I don't think there's anything in Title 15 that backs that up. Codes, the fees are kind of almost independent.
I think
I
you
mean,
find the
some-
same thing in state law. I can recall from my former position, and it does cause problems if the wording can lead the public to believe that something's legal or illegal when it's quite the opposite.
Yeah, so they should be, I guess the point there is that the code, it's silent about the code unless you see that the use is illegal. Good catch, Beth.
Bring Gary back.
Oh, yeah, that's a Gary question, yeah.
I think the first code change is on page 3, which has to do with fees at the alley dinghy dock, which we've had discussions about. Vessels up to 17 feet in length and must be less than or equal to 90 horsepower. And then we're striking at all public facilities except dinghy slips and bulkheads, 2 street and park ends, and 3 city public moorings to mooring dinghies to 17 feet.
Yeah, so the way it's been practiced since I've been there, and I've been told for many, many years, is that you get up to 12 feet and 25 horsepower at all of our city street ends except for Ego Alley.
Right.
We're trying to be welcoming to visitors that may have a bigger tender. And so it's also really nice for locals that specifically buy. There are lots of people that have specifically purchased a 17-footer with a 90 horsepower so the kids can go and get ice cream. And we want to continue that practice, but we want to make it clear what the rule is, because it's not good to have ski boats and boats that are not intended to be a tender or a dinghy or a smaller boat to come in for free and use our docks, because then there won't be room for the people that really are tendering in.
And so I was just trying to clarify that section, not really make any changes to practice.
So the one question, I have a constituent that had a 90 horsepower, 17-foot dinghy, and when she upgraded to 4-cycle, the comparable engine was 115. So she's bought a new motor, which no longer qualifies. So does that mean she can't be there at all, or if she's there, she has to pay a fee?
It would mean she has to pay the $8 per hour.
Right. So where is that in, does that $8 show up someplace else?
And it would be in the regular dockage section.
Okay. So it's not in the fees?
It should be, yeah.
Oh, okay.
There should be hourly fees right in there. If you're under 40 foot, you're paying $8 per hour.
There it is, yeah, on page 2. Up to 3 hours, up to 40 feet in length. Well, that's using slips.
Well, it's also the bulkhead is considered, they're considered slips
Okay,
as well.
all right, okay.
Anything other than that free dinghy area at the very end of Ego Alley.
So my constituent would appreciate me asking again, if would we consider making that 115?
What are your thoughts?
I
I think 90 is kind of high, honestly.
Pardon me?
I think 90 is kind of high. And I think we'll start to get the ski boats
Well,
in
that's-
again.
Yeah. Yeah, I mean, I think it's unfortunate that that the manufacturer changed it, but I agree with you. A 115 horsepower engine on a 17-foot dinghy probably would skate above the water. But nevertheless, I have to press forward my constituents' issues.
I can certainly look at it between now and July 1st because we'll get busy again. I
Okay.
can look at it on our busiest weekends.
Good.
The issue's going to come if there's no room.
Yeah, right, that's true. Well, and this is a person that uses it daily to go to work, which kind of a romantic idea,
Isn't it?
to take a dinghy to work, but that sounds like they're going to be pretty much a constant user of scarce space.
I agree.
I did it for a few years with a canoe.
Well, did you have a 115 horsepower engine?
No.
The next 3 are transient, no more than 48 hours, consecutive docking, no charge, that was stricken. At City Dinghy Dock, Kunta Kinte Park, and all public street ending and park docks per day, no charge, that was stricken. At City Public Mooring, see summer and winter public mooring fees above, that's stricken. And then storage, more than 48 consecutive hours consecutive docking is also stricken. All of those were no charge, so I assume that's just cleanup.
Yeah, they're all in conflict with code kind of things. You can't keep your boat more than 48 hours, so
Right.
I wasn't sure what we were listing that for.
Okay? The next one is a change from DNR to TFL.
Okay, so that one's a little more complicated to explain. Many, many years ago, while I was still a natural resources police officer, when the city waterways, when all of the waterways began to ice up, the city would offer very inexpensive docking for our waterman friends. It was great because then people coming downtown to Christmas shop got to see the crabs and oysters and rockfish coming in off the boats. McNasby's was still in full swing, and they could sell their seafood there, and they were also in a safe place to dock their boats. That practice has gone away. There hasn't been any of it for years and years. The reason is primarily because there are so few watermen left, and also the bay very rarely freezes over. It came up again this year with our very, very cold January. Could they please do that? And I thought it is just fine when we ice over to do that. But if we are to do that, the way it looks in the fee section now, it looks as if any waterman may do it at any time. And I actually had a commercial, self-proclaimed charter boat captain said, I can run my charter business out of City Dock, and it's only going to cost me $20 a week. And I think we all know that, A, that would not be in compliance with our full fees. I spoke to Bruce Miller about that, and B, that's not what that section's intended for. So I wanted to clean that up. Also, there's really no such thing as an oyster buy boat anymore unless it's for, unfortunately, very sadly, unless they're for like a historic display. And so I wanted to leave the wording in there because it's kind of cool. Maybe there will be one, I don't know. But I just wanted to clean that section up and make it as it was intended in the first place. So I don't have any more charter boat captains tell me they can keep their boat there for $20 a week.
But first of all, because of the 2 grants we took from Wildlife and Fisheries, no charter boats can be on city dock.
That's
period.
correct.
But the real question is, what is the switch from DNR, which I know, to TFL?
TFL means Title Fish License. I have to see the wording to remember it.
Okay.
I wanted to be clear there about someone with a Title Fish License as opposed to a waterman, as opposed to a fish guide.
Okay. All right.
And I think that has to stay in there because even though the grant encumbrance is there, if we get 110 Compromise Street back, that's where the waterman used to tie, from my recollection. So that wouldn't be in conflict with the grant.
Is 110 Compromise in play?
I'm told that we will get the lease back. I don't know if it's true.
Okay. Well, that'll be interesting, but controversial. So we also strike out per week in this thing. But the fee is $20 per week.
That might be a mistake.
Okay.
I don't think the fee is important. I don't think there will be more than 3 watermen that take us up on it per year.
Right. Okay. And then the next thing that's stricken is by boat activity engaged with certificate, current receipts, and current DNR number per week. Moorings shall not be used, and you've already explained that they're not, so you've stricken it. And then the one you started with was the $50 fee, street and dinghy permit available only upon medical hardship. So we heard an explanation on that, and I think that takes us through all the changes.
It looks like that's it.
Okay.
Anything else you would like to say about this?
No, really these were just to clean up some conflict because people felt like they were entitled to things that I don't really think the code intended for them to be entitled to. I'm really hopeful that we can find some places in city property where we can place some kayak or stand-up paddleboard racks. I haven't been able to spend time on that, but if anyone has any positive contribution towards that, I can understand as a city resident, you may not want to haul a smaller boat down to a street end every time you want to enjoy the waterway. But by the same token, I don't want the street ends cluttered with that because they tend to fill with water, they turtle over, people don't take care of them, and again, there's only a finite amount of space. So
Right.
if anyone has any ideas about places we could put a rack for kayaks and SUPs, I'd welcome any help with that.
Chair, I'd like to add that is a specific situation that Beth and I addressed last week, that, you can't, how else do I say this? To accommodate one request would open up others. And, this one particular request was a woman conditioned to doing it for 20 years because she wasn't told otherwise, But at least to my question, this Ms. Chess that you and I talked about, so she said, well, she didn't ask the question, she said, well, I'm just going to put it in the street. So then it's
Good luck
not,
with that.
so then it's not a, a city water.
It won't be my problem.
I know. So I guess that's what she's going to do. I don't know. I told her about looking
I mean, I
for
don't think
a
they look
rack.
bad, and I don't think people would mind having them. I don't know why we don't have any yet, except that we have mostly all private property touching our waterway, which is a problem throughout Anne Arundel County.
So essentially, you're asking about like some kind of public storage.
I mean, obviously, we can't do it at every street ending, there just
Yeah.
isn't room, but there might be some bigger ones that, because I'm not familiar with the parking too, because I don't want to try to provide a solution and create another problem.
Seems like it might, I like the idea, but what about the inspection component? Would it add additional work to your office? Or possibly, I mean, it could also just go to the rest of the Rec and Parks Department. Some of the larger parks that we have on the water's edge, you could definitely have
Yeah,
the room
like Mission
for
Barbecue
a
did.
structure. You definitely have room for structures there, but who's going to police whether or not people have approval to store their boats there?
It seems like we are able in most communities to get people to step up and do volunteer work in exchange for having this type of a benefit. I know, I know in neighborhoods, lots of neighborhoods, they have whatever is called like a peer governor or a person in charge of peers, and they may issue a number and make sure the canoes are locked up. I'm not sure, but I'm kind of urge these residents to help themselves, and I will be happy to help them as well because they have more local knowledge than me.
Mr. Chair, I think we have two bigger street-in park problems. One is we don't have floating docks at many of them anymore, and they're very expensive. I know the one at the end of 6th Street and Back Creek, that dock has been gone for a long time now. The other thing is we continue to have people filing quit claims to take away the street-in parks, particularly where the street-in is at the end of an alley rather than at the end of a street. And I have urged the Office of Law to have the city file quit claims on all of the remaining street-in parks that are untitled. And I've been running into difficulties that is an unconstitutional taking. But if the adjoining neighbors can file a quit claim, and we are an adjoining neighborhood from the street side, I don't understand why we can't. And in fact, I don't understand why we shouldn't file quit claims on all untitled property in the city. And there are thousands of untitled parcels for which we're not receiving property tax, but are being used by people even though they're not titled to do it.
Yeah.
So I would argue that this is a big issue, both getting floating docks at the end of the street-in parks, but also making sure that we keep control of all of the untitled street-in and alley-in parks before we lose even more access to the water. As Beth was saying, most property line, water line is privately owned. And a big issue for people all over, probably all over the world, but certainly in this county and the city, is access to the water. So maybe that's something we can put on our parking lot to bring up at another time, but I think we have to get after that. But then, if we did start to have more parks, then maybe there could be some parks that would be designated for kayaks and SUPs, because they are very popular, and kayaking, I think, is here to stay. I hope SUPs, most people will develop back problems and stop using them, but they're popular right now, and it is tough to lug them down to the water. And there are relatively few places where you can put them in. There's an issue in Ward 8 on Spa Creek where there is a right-of-way. Blue Heron condominiums are actually detached homes. There is a right-of-way to go from Boucher to the water, and unfortunately for the property owners, a young lawyer wants to take his boat there, and he finally has gotten the right to go through the right-of-way to put his dinghy in the water. But there's no doubt about it, the people who live next to these spaces try to acquire them legally or not. And so it's an issue that I think is overdue having the council take a look at.
Yeah, absolutely. I will add that to our list.
Thank you. It's just
Thank
growing
you.
and growing.
It
The
is.
other comment I wanted to make is I wanted to recognize that Beth has come in and tried to do things like this, clean up. And she's trying to enforce all of the code that for years has not been enforced or has been misenforced. And she's getting a lot of grief for it. So we need to figure out ways to support our harbor master, other than
Thank you.
attaboy.
Thank you, but I will say I have had a tremendous amount of support. I'm very grateful. I think it's the weekend emails that really eat at me because I'm not here to get the solution pushed forward, so I
Yeah.
sweat it.
Yeah.
I have a question on, Mr. Chair, on these racks. Could we look at them like bicycle racks and try to get some kind of a grant and be able to have the city or some, I mean, I know that we're having, we had the county put in bicycle racks, and is there any sort of funding source or
Well,
something like that where we could actually place them in?
I think they would be eligible for the 5K grants, and 5K grants, I'm told, are given freely and easily. And you can do 2 5K grants as a 10K grant if you have a bigger project. So I'm just now delving into that for Lafayette.
Okay.
And as soon as I work through my first application, then I'll know more as to how they work. But my hunch is that's access to the waterways. I hope that money's available for smaller boats as well. Feels like the focus from DNR is on big boats. But I don't know all the details. And I think what I've heard from DNR is you can always use the argument that people are using the small boats to get to bigger boats. Kind of convoluted, but if you get the grant and you comply with the terms.
If you haven't done so already, I'd encourage you to reach out to the Annapolis Conservancy Board and maybe even the Environmental Commission, but also Spa Creek Conservancy. They're all volunteers, but they all have missions that I think would support and that would support that goal of getting some more structures for the residents to store their boats on. And I'm sure they'd be happy to help you out
Okay.
in any way they can.
Just as soon as that slow time comes.
Yeah.
I'm just kidding.
Yeah.
I will put it, I definitely think that's a
Yeah.
good idea.
Well, the Conservancy Board also has they have access to some of their easements, conservation easements that they've gotten over the years, some of which are near the water.
I just hope that if we're able to, move forward with a project like that, unfortunately, I still always get those people that say, well, but it's not at my house. I know, it's not at your house. Just to let you know, like, how long people have been given privileges that they were never entitled to. That is often the response, but it's not at my house. Okay, all right.
So we should put SUP and kayak racks on the front of all of our circulator buses.
There you go. Well, do I have a,
Yeah, I move that we recommend favorable. Okay.
I second that.
all those in favor?
Aye.
Thank you.
Thank you so much for your time and all your
Sure.
work. Keep them coming. I'm sure we'll be glad to
Yeah.
help you out however we
When the weather
can.
gets nicer, please come out for a boat ride on our new boat.
Oh.
Once you see things from the water, it really does help with your perspective on some of these things.
Yeah.
That would be fun.
definitely. Yeah. Thank
Yeah.
you.
Let us know.
Thank you. Let's see. Do we have anything else?
Well, we don't have anything else other than this.
I'm going to
David
all
looked
right, call a
very,
recess until Public Works shows up.
can we get everybody a copy of the briefing that, do you have this, Ellie? I have it too, but I don't think you do. Because look at the size of these pumping stations. I cannot believe, and I talked with David one time before, and he said, turn my
about the commercial break.
I'd like to call Environmental Matters back in session. So, Public Work. Okay. Ready? All right, I'm going to call Environmental Matters back in session. Public Works is unable to attend, so we will reschedule with them for April 18th, at the next Environmental Matters Committee meeting, for a presentation on the flood mitigation pumps downtown. And also for my colleagues, I'm also planning on inviting David Barker with Back Creek Conservancy to talk about the no discharge zone at that meeting.
Okay.
And if there's anything else we can talk about adding to the agenda.
Okay.
So I will entertain a motion to adjourn.
So moved.
All in favor?
Oh, you're supposed to say that first.
Second? All in favor?
Aye.
Aye.
Aye. I forgot the second. I was just going to look to see when this